My name's Louise Merrill. I'm an associate in the employment team at Clarks Legal. This is the 7th podcast in Clarks Legal's Tupian 10 podcast series and focuses on the restrictions on changing terms and conditions for transferring employees. The overall aim of TUPE is to protect the rights of the transferring employees. Therefore, the automatic transfer principle means that employees assigned to the relevant business or organised grouping transfer to the transferee on their existing terms and conditions of employment, with some limited exceptions. In addition, TUPE imposes restrictions on the ability of either the transferor or the transferee to change the employee's terms and conditions. This restriction on changing terms and conditions is in addition to the general law relating to contract changes, i.e. that changes can only validly be made in accordance with the terms of the contract or with the agreement of the parties. Under TUPE, any change to terms and conditions of employment is void if the sole or principal reason for the change is the transfer itself. And this restriction applies to both transferees who seek to make changes to the transferring employee's terms and conditions after the transfer, and to transferors who seek to make changes to the transferring employee's terms and conditions before the transfer, for example, where they want to make the business look more attractive to a buyer. Now, in many situations, it's clear that the reason behind the change to terms and conditions is the transfer. However, it's not always straightforward, it's not always clear, and there is a lot of case law in this area. The Department for Business, Innovation and Skills produced guidance which suggests that for a change to be unconnected to the transfer, there has to be an extenuating circumstance, some factor other than the transfer itself, which has led to the change to terms and conditions. This is always a question of fact and degree for the tribunal to determine in the event of a dispute. Let's look at If following the transfer, the employee accepts a promotion with the employer that results in a new contract, then the reason for any changes is likely to be because of the new role and not the transfer. However, if an employee is given new terms post-transfer to simply harmonise his or her contract with the rest of the transferee's workforce for ease and simplicity, then this change will be because of the transfer and will be void. So what happens if you do make a change prohibited by TUPE? Well, it's void and legally unenforceable. Interestingly, however, case law has confirmed that only changes which are detrimental to the employee are void, and any changes that are beneficial to the employee, even if the sole or principal reason for that change was the transfer, they're valid and enforceable by the employee against the employer. Therefore, employers could be left with employees cherry-picking the best of both of their contracts. Now, this is obviously not ideal for employers, and there are mechanisms available for an employer seeking to make changes which would be prohibited by TUPE, but they're very complicated and not completely risk-free. So please get in touch with us if you need further advice on that area. So what changes will be permitted? Well, changes unrelated to the transfer will be permitted, like the promotion example that I gave earlier. Changes where the sole or principal reason is economic, technical or organisational, and it entails changes in the workforce, otherwise known as an ETO reason. If the existing terms of the contract permit the employer to make the change, they'll be allowed, for example, a specific mobility clause to move elsewhere and work in another office. If the terms have been incorporated from a collective agreement, they can be varied, provided the change takes place more than a year after the transfer date, and that the terms, when considered together, are no less favourable to the employee than the original terms. If the change is entirely beneficial to the employee, then as I've mentioned, those changes can take effect, and there'll be a certain amount of flexibility in insolvency situations with regard to changes to terms and conditions, but that's outside the scope of this podcast. As mentioned previously, the usual rules on changing contract terms apply, and so changes can only be made as stated in the contractual terms or with the individual's agreement. As mentioned, changes can be made if there's an ETO reason. Let's break this test down. So first, you have to show that there's an economic, technical or organisational reason for the change. Examples include a reason relating to the profitability or market performance of the transferee's business. That might be an economic reason. A reason relating to the nature of the equipment or production processes which the transferee operates. That might be a technical reason. And a reason relating to the management or organisational structure of the transferee's business. That might be an organisational reason. Then second, you need to show that this reason entails changes in the workforce. This means that the change will result in a change in numbers, functions, or the employee's place of work. Now, it's usually pretty easy to satisfy the first part of the test, but it's the second part that's a lot more difficult. TUPE is extremely fact sensitive, so let's end by having a look at some of the cases on changing terms and conditions. In the case of Campbell and Martin McCall, Mrs. Campbell was a store assistant. The store was acquired by another company, Martin McCall Limited, and this involved a TUPE transfer in 2008. Martin McCall sought to introduce changes to harmonise the terms of Mrs. Campbell's employment with existing staff, and these changes involved removing elements of sick pay and holiday entitlement. In 2010, Mrs. Campbell and others wrote a letter questioning whether Martin McCall could make these changes, and in reply they were told that for a number of years staff had operated inconsistently in this regard and that the changes were to meet organisational need and economic circumstance. Store managers were then asked to issue new contracts. The tribunal held that this was a void change under TUPE despite the delay in implementing the changes. The principal reason for the variation was to harmonise the entire workforce terms and conditions, and that was not permitted. Further, there was no ETO reason because the change didn't entail a change in the workforce. In the Enterprise Managed Services Limited and Dance case, EMS Limited held a contract to provide maintenance services to a client. The client raised concerns about maintenance standards and cost, and so EMS Limited introduced a performance-related pay system for staff working on that contract. EMS Limited then won another contract with the same client, and there was a TUPE transfer whereby EMS Limited inherited employees. EMS Limited applied the same performance-related pay system to those employees. The tribunal found that this was harmonisation and that any improvement in productivity was a consequence of that. However, on appeal, the Employment Appeal Tribunal held that EMS Limited had not tried to harmonise terms out of a simple wish for ease and tidiness across its workforce, but had pushed for the changes due to the success of the changes in improving productivity, which were demonstrated by the pre-transfer results. The success was not a consequence of harmonisation, it was the driving force behind the change, the reason for the change. The EAT felt that since it was open to the employer to effect a productivity change in accordance with all the ordinary laws, the changes don't become unlawful simply because there's been a relevant transfer, so it allowed that change on those facts. In the final case, Smith and others and trustees of Brooklands College. So in this case, the employees were part-time teaching assistants, but they were being paid full-time rates. Following a TUPE transfer, the HR director reduced their rates of pay because he believed the existing rates were a mistake, as no one else in the sector had this pay arrangement, and it was contrary to the guidelines that had been set out by the employees' own trade union. The Employment Appeal Tribunal upheld the tribunal's decision that the reason for the change was not because of the transfer, it was the mistaken belief of the HR director that these individuals had been mispaid. It was not enough that the change would not have happened but for the transfer. As you can see from these cases, when changes will be permitted is not at all straightforward, and you need to seek advice in most cases before making any such changes. This podcast, I hope you found it helpful. The next podcast in the series will be focusing on the additional protection against dismissal that TUPE offers to employees. Thank you, and I hope you catch the next instalment of the series.